5 seconds to go. Start. As such, the two provisions cannot be equated. The legislature has deliberately avoided reference to the grounds mentioned in Section 41 and considered it appropriate to impose strict and stringent conditions that act as a safeguard. The same reasoning will apply to the contention raised by the DOE, relying upon the provisions of Section 437 of the Code and the judgment of this court in Gurcharan Singh and others versus State Delhi Administration. Section 437 of the Code applies when an accused suspected of committing a non-bailable offence is arrested or detained without warrant by a police officer in charge of a police station or is brought before a court other than the High Court or the Court of Sessions. It is observed that the accused would be released on bail except for in cases specified in clauses 1 and 2 of Section 437(1) of the Code. Section 437(1)(1) applies at the stage of initial investigation where a person has been arrested for an offence punishable with death or imprisonment for life. Section 437(1)(2) imposes certain fetters on the power of granting bail in specific cases when the offence is cognizable and the accused has been previously convicted with death, imprisonment for life, or 7 years or more, or has previously been convicted on 2 or more occasions for non-bailable and cognizable offences. The power under Section 437(1) of the Code is exercised by the court other than the High Court or the Sessions Court. In other cases, Section 437(3) of the Code will apply. Gurcharan Singh Supra distinguishes between the language of two subsections of Section 437, Section 437(1) and 437(7). It is observed that 437(7) does not apply at the investigation stage, but rather after the conclusion of trial and before the court delivers its judgment. Thus, the use of the expression not guilty pertains to releasing the accused who is in custody on a bond without surety for appearance to hear the judgment delivered. Notably, Section 437(6) states that if the trial of a person accused of a non-bailable offence is not completed within 60 days from the first date fixed for taking evidence, the magistrate, to their satisfaction, shall release such person on bail, provided they have been in custody throughout this period. The magistrate may direct otherwise only for reasons recorded in writing. Section 439 of the Code, which relates to the power of the High Court or the Sessions Court to grant bail, remains free from the legislative constraints applicable in cases covered by Section 437(1) of the Code. However, Section 437(3) of the Code, when applicable, applies. DOE has drawn our attention to the use of the expression material in possession in Section 19(1) of the PML Act instead of evidence in possession. Stop.